My name is Judge Terrence Holmes, and I'm the presiding judge here in County Court at Law Number 2. You have been asked to come to court this morning for what we call an arraignment. And what the arraignment is an opportunity for the court to tell you what you've been charged with, what your rights are, and what your options are concerning your case. The case that you have in this court is a criminal case. It is a misdemeanor criminal case. Criminal cases are divided into felonies or misdemeanors. Now, your felony cases are normally referred to as your more serious type offenses, whereas your misdemeanor cases are normally referred to as your petty offenses. Now, it does not mean that they are not serious. It just means that they're not as serious as a felony case. And when I use the term serious, what I'm talking about the facts of the case and the possible punishment that a person can receive if they are convicted of the offense. Now, your felony offenses are divided into 5 categories. And we'll start at the top and work our way on down to the bottom. You have the capital murder, first-degree felony, second-degree felony, third-degree felony, state jail felony. If a person is convicted of a state jail felony, the range of punishment is minimum 6 months to a maximum of 2 years in the state jail and a fine that does not exceed $10,000. If a person is convicted of a third-degree felony, the range of punishment is minimum 2 years to a maximum of 10 years in the state penitentiary and a fine that does not exceed $10,000. If a person is convicted of a second-degree felony, the range of punishment is minimum 2 years to a maximum of 20 years in the state penitentiary and a fine that does not exceed $10,000. If a person is convicted of a first-degree felony, the range of punishment is minimum 5 years to a maximum of 99 years to life in the state penitentiary and a fine that does not exceed $10,000. Now, if a person is convicted of a capital murder, which is the highest felony, the range of punishment is life in the state penitentiary without the possibility of parole or death by lethal injection. Now, as I mentioned to you earlier, your offense is a misdemeanor offense. And so you don't have to worry about that punishment that I just mentioned. Now, misdemeanors are divided into 3 categories. We'll start at the top and work our way down to the bottom. You have the Class A misdemeanor, Class B misdemeanor, and the Class C misdemeanor. If a person is convicted of a Class C misdemeanor, then they can be assessed a fine from $0 up to $500. Now, with a Class C misdemeanor offense, you cannot get any jail time. It is by fine only. Now, the Class C misdemeanors are offenses that originate or start in the city court or the JP court. And then the case comes to this court when a person is found guilty in the JP court or the city court, and then they appeal their case. And then it comes to this court. When it comes to this court, they get a whole new trial. We go back to square one. I said that to say this, that your punishment does not change. It's still by fine only of $0 to $500. Now, if a person fails to pay the fine, or if the fine was converted to a community service officer. Okay, so as I mentioned earlier, now if a person on a Class C misdemeanor failed to pay the fine, or they failed to perform the community service that they were required to perform, then the court can issue what is called a capias pro fine. That simply means that it's a warrant for your arrest to either pay the fine or sit the fine out in jail. Now, when we talk about sitting the fine out in jail, a person can, for every 1 day that a person sits in jail on the case, they will receive $100 credit toward the fine and court costs. Now, the next highest misdemeanor is a Class B misdemeanor. And the range of punishment for a Class B misdemeanor is minimum 0 days to maximum 180 days, which is 6 months in the county jail, or a fine that does not exceed $2,000, or you could be given both such fine and confinement. If a person is convicted of a Class A misdemeanor, the range of punishment is minimum 0 days to a maximum of 365 days in the county jail, a fine from $0 to $4,000, or a person can be given both such fine and confinement. Now, before I go any further, make sure everyone who have a phone, make sure your phone is either turned off or on silent. Now, the next thing is, as a defendant in a criminal case, you have rights. One of the rights that you have, and we're going to talk about that, the first right is your right to have an attorney. Now, the clipboard that you have in your hand, it should be a document on that clipboard that's titled Judge's Explanation of Rights to Defendants Without Attorney. Everyone needs to turn to that document. I'm going to go over that document with you. And it states, as a defendant in a criminal case, you have 3 options. Number 1, you may hire an attorney. Number 2, if you do not have enough money to hire an attorney, you may request that an attorney be appointed by the court to represent you. Number 3, you may represent yourself. So those are your 3 options. Now, it further states that if you want an attorney to represent you and you have enough money to hire an attorney, your case will be reset. Reset means you'll be given another court date to give you time to hire your attorney. If you want an attorney to represent you, but you do not have enough money to hire an attorney, then you would have to fill out a financial questionnaire. Now, the financial questionnaire is also a document that's on the clipboard, and it is titled Jefferson County Affidavit of Indigence. You will have to fill out the first page, the entire first page, and then half of the second page. Okay. Once you fill that document out, then the proper person will determine whether or not you qualify to have an attorney appointed to represent you. Now, if you want to represent yourself, then you would have to fill out a document on that clipboard that is titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. You would only read and sign that document if you want to represent yourself. If you don't want to represent yourself, you don't need to read and sign that document. Okay. Now, if you want to represent yourself, and once you fill out that document, you'll have an opportunity to talk to one of the prosecutors that's sitting at the table before you. And the reason why you'll have an opportunity to talk to them, because at that point, you are representing yourself. You are your own lawyer. Now, if you are not representing yourself, then your attorney will have an opportunity to talk to them. Now, you should be aware that there are dangers and disadvantages of self-representation. Waiving your right to an attorney and representing yourself may result in a worse outcome for you and your case, including the loss of significant rights and opportunities relating to military service, possession of a firearm, housing and public benefits, child custody, immigration status for non-citizens, and employment. Now, if you choose to represent yourself, you may change your mind at any time and request that an attorney be appointed to represent you. Now, at the bottom of that document, the document that is titled Judge's Explanation of Rights to Defendants Without Attorney, at the bottom of that document, in bold letters, it states defendant's choice, mark initials next to only one choice. If your choice is to hire your own attorney, then you will place your initials on the first line to the left. If you have already hired an attorney to represent you in your case, then you will place your initials on the second line to the left and the name of the attorney on the line to the right. If you want to apply for a court-appointed attorney, that is, you can't afford to hire an attorney, you'd like to apply for a court-appointed attorney, then you will place your initials on the third line to the left. If you have already been appointed a court-appointed attorney to represent you in your case, then you will place your initials on the fourth line to the left and the name of the attorney on the line to the right. If you want to waive your right to an attorney, that is, give up your right to an attorney, you want like to represent yourself, then you will place your initials on the fifth line to the left. Once you have finished initialing one of the 5 lines that I just talked about, then you will sign your name on the line that is titled defendant, and you will date it today's date, September 17th of 2024. Okay. Now, for those individuals who will be waiving their right to an attorney, those individuals who like to represent themselves, then you will read and sign the document that is titled Waiver of Counsel. Now, he needs a clipboard? Okay, we have some more. You need a okay. Okay, hold on a minute. Now, at the bottom of that document, that first document, Judge's Explanation of Rights to Defendants Without Attorney, as I mentioned to you earlier, if you want to hire your own attorney, you'll place your initials on the first line to the left at the bottom. If you already have an attorney representing you, then you'll place your initials on the second line and the name of the attorney. You're going to place your initials on the second line to the left and the name of the attorney on the line to the right. If you would like to apply for a court-appointed attorney, you'll place your initials on the third line to the left. If you have already been appointed a court-appointed attorney to represent you, then you'll place your initials on the fourth line to the left and the name of the attorney on the line to the right. If you would like to waive your right to an attorney, waiving means give up. If you want to give up your right to have an attorney, you would like to represent yourself, then you'll place your initials on the fifth line to the left and the name of the attorney on the line to the right. What? Strike that. You'll just place your initials on the fifth line to the left. Now, once you have finished initialing one of the 5 lines, then you will sign your name on the line at the bottom of that document that's titled defendant, and you will date it today's date, September 17th of 2024. Now, for those individuals who will be desiring to represent themselves, then you would have to read and sign the document that is titled Waiver of Counsel for purposes of entering a guilty plea or proceeding to trial. And that document states as follows. I have been advised of the nature of charges against me and the dangers and disadvantages of self-representation. My waiver is voluntarily and intelligently made. Voluntarily means that you are doing it of your own free will. No one is forcing you to do it. Intelligently means that you know what you are doing. So you're saying that my waiver is voluntarily and intelligently made. Furthermore, I have been advised the 17th day of September 2024 by County Court at Law number 2 of my right to representation by counsel in the case pending against me. I have been further advised that if I'm unable to afford counsel, one will be appointed for me free of charge. Understanding my right to have counsel appointed to me free of charge, if I'm not financially able to employ counsel, I wish to waive that right and request the court to proceed with my case without an attorney being appointed for me. I hereby waive my right to counsel. If that is your choice, then you will sign your name on the line that is titled defendant, and you will date it today's date on the line that's titled date, and the day's date is September 17, 2024. And again, only individuals who will be waiving their right to an attorney representing themselves should read and sign that form. Okay. Now, as a defendant in a criminal case, you also have a right to have a trial by jury. Where those young ladies are sitting in that area, we call that the jury box. 6 citizens from Jefferson County will be selected to serve as jurors in your case. They will listen to all the evidence. They will listen to all the arguments that are made by the state and the defense. They will retire to deliberate, and then they will decide whether to find you not guilty or guilty of the charges. You also have a right to waive or give up your right to have a trial by jury. That is, you have a right not to have a trial by jury. Now, if you give up your right or waive your right to have a trial by jury, your case will come before the court or before the judge in one of 3 ways. One way it can come before the judge is by way of a bench trial. Bench trial is a trial by judge only. The judge will be the judge and the jury in the case. The judge will listen to all the evidence, listen to all of the arguments. The judge will apply the facts to the law, and then the judge will decide whether to find you not guilty or guilty. The other way that your case can come before the court is by way of a plea bargain. Now, plea bargain basically means that you and the state have reached an agreement to settle your case. That's, in a nutshell, that's what it means. Now, your case can come before the court by way of a agreed plea bargain or an unagreed plea bargain. Agreed means that you and the state has reached an agreement. Unagreed means that you and the state have not reached an agreement. And if you and the state have not reached an agreement, the case comes before the judge by way of an unagreed plea bargain, then the judge will assess the punishment in the case. In essence, you plead guilty of no contest. Guilty means you're telling the court that you committed the offense that you've been charged with. No contest means that you're not fighting or contesting the charges. Or if you plead not guilty, you're telling the court that you did not commit the offense. So if you plead guilty of no contest and you have an unagreed plea bargain agreement, it comes before the judge will assess punishment within the punishment range of the offense. And what I mean by within the punishment range, if it's a class A misdemeanor, your punishment will be anywhere from 0 days to 365 days in the county jail, a fine from $0 to $4,000, or you could be given both such fine and confinement, or the judge could give you probation. The other way it can come before the judge is by way of an agreed plea bargain. Agreed plea bargain means that you and the state has reached an agreement. So it comes before the judge. The judge can do one or two things. The judge can either accept your agreement or reject your agreement. Now, if the judge rejects the agreements that you make with the state, you can take back your plea or you can withdraw your plea. For example, let's say you and the state have worked out a plea bargain agreement, and judge and the state say, well, judge, we're going to give Mr. John Doe probation. And the judge says, well, I'm going to reject that plea bargain agreement. Then Mr. John Doe can say, well, judge, since you are not following the agreement, I take my plea back. In essence, I'm not pleading guilty or not pleading no contest. You have a right to do that. Now, if the judge accepts the plea bargain agreement and you decide that, hey, you know what, I think I've been wrongfully convicted or the court committed an error by convicting me, I want to appeal my case. If you want to appeal your case, if the judge has went along with the plea bargain agreement, you have to get permission from the judge. Now, if the judge gives you permission, then the case is going to leave this court and it's going to go to the Ninth Court of Appeals, which is located right above us on the 3rd floor. They will review your case. They will decide whether to accept, they will decide whether to grant or deny your appeal. If they grant your appeal, they can simply find you not guilty. Or they can send the case back down to this court and order this court to give you a whole new trial. If they deny your appeal, then you can appeal it to a higher court than the Ninth Court of Appeals. You can appeal it to the Texas Court of Criminal Appeals, which is the highest criminal court in the state of Texas, and they're located in Austin, Texas. Now, you would have to file what is called a pro se petition for discretionary review. Now, pro se means that you're representing yourself. You won't have a lawyer when you file your pro se petition for discretionary review. You'll be petitioning the Texas Court of Criminal Appeals in Austin, Texas, to review your case, to see whether or not your appeal should have been granted, whether or not you were wrongfully convicted in this court, or whether or not this court committed an error by convicting you. Now, they can do one or two things. They can grant or deny your pro se petition. If they grant your pro se petition, they can simply find you not guilty. Or they can send the case back to the Ninth Court of Appeals with orders, or they can send it back down to this court, or in this court to give you a whole new trial. Now, if they deny your pro se petition, then at that point, your conviction will stand. Okay. Now, as a defendant in a criminal case, you not only have a right to have a trial, right to have an attorney, you not only have a right to have a trial by jury, or right to have a bench trial, or right to have an unagreed plea bargain, or right to have an agreed plea bargain, you also have a right to have witnesses to come to court to testify. They can testify for you or against you. Witnesses, they sit in that chair right there. We call it the witness stand, the chair with the microphone. And they can testify for you, against you. You can ask them questions if you represent yourself, or if you have an attorney representing you, your attorney can ask them questions. We call that either direct examination or cross-examination. Now, you also have a right to waive or give up your right to have a trial, to have witnesses to come to court. If you waive or give up your right to have witnesses to come to court, what that means is it means that you will not be calling witnesses. It does not mean that the state will not be calling witnesses, because the state will be calling witnesses in this case. Now, you also have a Fifth Amendment right against self-incrimination. I know sometimes we watch these programs on televisions, these programs that talk about law and order, and somebody's on the witness stand, or maybe they're at the police station, and they're saying, well, I take the act, and the police is trying to ask them questions, or the lawyer is trying to ask them questions. They say, well, I take the fifth. And what that means is they're saying, I'm not testifying. I'm taking the fifth. That is the Fifth Amendment right against self-incrimination. That means you have a right not to testify in yourself against you. You have a right not to testify against yourself. Okay? You have a right not to incriminate yourself. Now, if you take the fifth, the state prosecution, district attorney's office, the government cannot force you to take the witness stand. If you waive or give up your right and you desire to take the witness stand, then you can do so if you waive or give up your Fifth Amendment right against self-incrimination. But if you exercise it, they can't force you to take the witness stand. Now, the other thing is you have a right to have what we call discovery. What discovery is, you have a right to see the evidence that the state has in the file. For example, you have a right to see witness statements, your statements, police reports, lab reports, photos. You have a right to see video recordings, listen to audio recordings, right to have access to any type of documents or instruments that the state will be using against you in your case. You also have a right to waive or give up your Fifth Amendment right against self-incrimination. Now, everyone that's here today for your case, you have been arrested. You have been placed in jail, and you're bonded out of jail. You're out of jail on bond. You're either out of jail on what is called a cash bond, which means that you paid the full amount of the bond to get out of jail, or you're out of jail on a surety bond, which means that you paid a bondsman a percentage of the bond to get out of jail, or you're out of jail on a PR bond or a personal recognizance bond, which means that you did not have to pay any money to get out of jail. You were released under your own personal recognizance with a promise to appear here in court today. Now, every day that you spent in jail, you can receive credit toward your punishment. Now, notice I said every day that you spent in jail. If you went into jail, you was booked into jail at 11:59 p.m. at night, and then you bonded out of jail at 12:01 a.m., which is 2 minutes later, you get credit for 2 days. Why? Because it's 2 different days. So it's not 24 hours. It's just that it's 2 different days. Okay? So every day that you spent in jail, you can receive credit toward your punishment. So for example, let's say you spent 5 days in jail. Let's say you and the state have reached a plea bargain agreement for you to serve 5 days in jail. That simply means you will not have to serve any more time in jail because you've already served 5 days in jail. Therefore, you'll be given credit for the time that you have already served. Now, if the state is offering 7 days in jail and you serve 5 days in jail, that simply means you will only have to serve 2 days in jail. Why? Because you've already served 5, and we'll take 5 from the 7, and that leaves 2. Now, every day that you spent in jail can also be used as credit toward your fine and court costs. You're credited at $100 per day for every day that you spend in jail. So if you spend 5 days in jail, that's $500 that can be used toward your fine and court costs. And so if the state is offering you a fine and court cost of $500, that means you will not have to pay anything. Why? Because you've already served 5 days in jail. That's $500, and the $500 will be taxed and retired. Now, if the state is offering fine and court costs of $700 and you serve 5 days in jail, which is $500, that means you will only have to pay $200. Why? Because you already have $500 credit that will be subtracted from the $700, and that leaves $200. Now, you'll be required to pay the $200 on the day that you dispose of your case. If you cannot pay the remaining balance on the day that your case is disposed of, then we can put you on what is called a payment plan. You can pay off your balance so much per month. Now, even if we put you on a payment plan and you cannot pay it off, no problem, because we can convert the fine and court costs to community service. You receive $12.50 for every 1 hour of community service that you perform. So, for example, if you owe $200, you get $12.50 for every hour that you perform. If you work 8 hours one day, that's $100. You work another 8 hours, that's $200. You work 2 days at 8 hours a day, you've already paid off your fine and court costs. Okay? the balance of $200. Now, Jefferson County has a program for people who have never been in trouble before. It's your first time getting into trouble. They have a program where they will dismiss your case and you can get it wiped off your record. The program is called pretrial diversion. And the way the program works is as follows. It has to be your first time getting in trouble. It cannot be an offense for unlawfully carrying a weapon or resisting arrest. And then the third thing is you have to have an attorney to help you make the application or submit the application to the district attorney's office. If you get into the program, the case is dismissed. You can get an expunged. Expunged means wiped off, deleted, or erased from your record. It's like it never happened. Okay? If you're interested in the program, when you come up, just let us know, and we will direct you to the person that you need to talk to get into that program. Now, if you are a veteran of any one of the branches of the United States military, the DA's office has another program that is called Veterans Court. Veterans Court is a program for veterans only. And what they will do, you get into the program, you complete the program, they will dismiss the case, and you can get what is called a non-disclosure. A non-disclosure means that we, or the government, we cannot disclose the fact that you were on deferred probation to the general public. Notice I said to the general public. The government can have access to it, but the general public, which is most of the public, cannot have access to the record if you get a non-disclosure. So if you're a veteran of any one of the branches, you're interested in that program, just let us know, and we can direct you to the person that you need to talk to get into that program. This court, County Court of Law Number 2 of Jefferson County, Texas, has a program that is called the CSI program. CSI stands for, it's an acronym that stands for Community Safety Initiative. It is a program that I started within the first 100 days of taking office. I started this program in March of 2017. So we've had this program for the past 7 years. With this program, the program is designed to address the issue of what we call recidivism. Recidivism means that people commit crimes over and over. They call it recidivism. And so how do we stop people from committing crimes, or how do we address it? Well, we address it through our Community Safety Initiative. With this program, we have partnerships with agencies in our Southeast Texas region. One of the agencies that we have a partnership with is called Spindletop Center. Spindletop Center is our local mental health center in the Southeast Texas area. Spindletop, they're going to come to you and tell you more about the program in a few minutes. But basically what Spindletop will do, Spindletop has the expertise to address your mental health needs. Now, Spindletop, they will conduct a private interview, either in our jury panel, in our jury room, at their facilities, or by telephone, whichever is convenient for you. They will also, they have the ability to do an assessment, that is to determine what your mental health issues are. They also have the expertise to develop a treatment plan for either outpatient or inpatient. Now, you do not have to be incompetent or insane to participate in the program. You could merely suffer from anxiety or depression or any other host of mental illnesses. They have the ability to address those issues. If you have issues with drugs or alcohol, then Spindletop has a program that is called ATAR, A-T-A-R, which stands for Addiction Treatment and Recovery. We also have a partnership with our Golden Triangle, with the our local Drug and Alcohol Council that has a program that is called OSAR. OSAR is O-S-A-R, that stands for Outreach, Screening, Assessment, and Referral. Both of those programs are drug and alcohol recovery programs. They have the ability to conduct an assessment, do a screening, and they could develop a treatment plan for either outpatient or inpatient to address your drug or alcohol issues. If you're unemployed, or if you're looking for a better job, we have a partnership with the Golden Triangle Empowerment Center, who has a partnership with Lamar University. Lamar University has a program that is called CICE. It's an acronym that stands for Center for Innovation, Commercialization, and Entrepreneurship. It is a job training and a job placement program in the hotel industry, the shipping industry, or the chemical industry. Once you are trained in any one of those areas that you select, they will assist you at getting a job in the area that you're trained in. If you have not graduated from high school or you have not received your GED, they also have a GED program where you can receive your graduate equivalency diploma. Now, all of these programs that I just mentioned to you are free. Does not cost you anything but time. And I like to say in this court, we don't just give time, we take our time. That is, we do not just arrest the problem, we address the problem. And we believe that if we address the problem, we can produce productive people. And if we produce productive people, we can make Jefferson County a safer place, because productive people have too much to lose. And so I like to say that when you come to County Court at Law number 2 of Jefferson County, Texas, we do not just have court as usual, we have unusual court. And it's not because we're different, but it's because we're trying to make a difference in the lives of the individuals that come before this court. And if we make a difference in their life, we will make a difference in their home. And if we make a difference in their home, we will make a difference in the community, because what comes out of the home goes into the community. So if you're interested in any one of these programs, just let us know. Now, the other thing about these programs, all of these programs that I just mentioned can be used as community service. So for example, let's say in my example that I gave, you had a fine and you could not pay the fine. And so we converted it to community service. Every 1 hour that you perform, either in the job placement program, in the drug treatment program, or the mental health program, or the GED program, for 1 hour sitting in GED class, or in job while you're being trained for a job, $12.50 will go toward payment of your fine and court costs. And 1 hour is going toward the community service. Okay? So it's kind of like you killing not 2 birds with 1 stone, but 3 birds with 1 stone. While you're doing one thing, you're being credited for 3 things. You're being credited for being in the program, the community service, and paying your fine and court costs. So if you're interested in any one of these programs, just let us know. And we have people here in the court, and I have brochures that we can give to you so that you can get into the program. Now, as I mentioned to you earlier, we have some folks from Spindletop, and we're going to have our folks from Spindletop who is going to come to you and tell you more about the program that Spindletop has to offer. We have Deputy Hinton and we have Chloe. Deputy Hinton and Chloe, you can come forward.
Thank you, Your Honor.
You're welcome.
Good morning. My name is Steve Hinton. I'm a mental health deputy licensed by the state commission here at the sheriff's office. I'm here with my coworker, Chloe. Now, Chloe is a qualified mental health professional. The reason we are both here this morning in this courtroom is because the judge cares about every single person that comes before him. What the judge has found was statistics prove that those that you commonly have mental health needs, substance use disorders, or sometimes just a lack of community resources to help you with a particular situation.
There's many things like depression and anxiety that a lot of people may go through just going through the whole court process as a whole. And also there's a lot of projects and community organizations that are well funded but not well advertised. And we're just here to connect you with those resources and be an open ear or someone to talk to at times of need.
So maybe this is your first time to be in court, it could be your 5th time to be in court, there's still hope. In fact, what we're offering you has the ability to change your life. We're gonna need something from you. We're gonna need you to share that need with us. And Chloe will explain exactly how you can do that very privately.
So when everyone walked in, I gave each one of you a resource connection form. You're just able to fill out all of your information on here and mark off if you want to speak with me privately today about any concerns you may have, or, be contacted via text, email, or phone call. Now, everything you put on this form is protected under HIPAA. All governing bodies cannot be shared with anyone. So, if y'all feel the need to connect with resources or just talk or want me to check up on y'all after court, be sure to fill this out.
Also, I have a card here I want to give everyone. It has a 1-800 number on there. Should you ever find yourself in an unsafe place, you can call that number immediately. It's going to be the first resource we can actually give you. So when the judge goes into recess shortly, we will be able to come out there. We'll visit with you. We'll pick up those documents from you, and I'll be handing this out to everyone. We'll answer any questions you may have at that time as well. Thanks for your time. Thank you, Your Honor.
Thank you, Deputy Anthony Chloe. Now, ladies and gentlemen, the paperwork that you have in your hand, we're gonna pick that paperwork up from you now. If you need any help in filling out the paperwork on the clipboard, we have our court personnel who's here, who's willing and able to help or assist you with filling out the paperwork. You can just basically simply raise your hand, and then when they see your hand raised, they'll come out and they'll assist you in filling out that paperwork. Now, once the paperwork is filled out, our court personnel is going to pick that paperwork up, and we're going to go through the paperwork, and then we're going to call you up before the bench. This is the bench, one at a time. And once you finish here, then you'll move to the court coordinator to have your case taken care of. Now, this is gonna take us a little time to do. So if you need to use the restroom, there are some restrooms right outside of the courtroom in the hall. The men's restroom is on this side of the hall in front of County Court at Law number 3. The women's restroom is on the opposite side of the hall in front of the 172nd District Court. You'll be allowed to go out into the hall, use your restroom, and then you got, come back here. Do not leave the courthouse. If you leave the courthouse, and if your name is called, you do not answer, your bond can be forfeited. And if your bond is forfeited, a warrant will be issued for your arrest. You'll be arrested and placed in the Jefferson County Jail. So as I mentioned to you earlier, this is going to take us some time, a few minutes to pick up the paperwork from you. And so, again, if you need to use the restroom, they're right outside in the hall. Now, again, if you need assistance, just please raise your hand, and we'll have someone from our staff to come out and assist you. And also, Deputy Hinton and Chloe is going to visit with you as well. Okay? So at this time, the court will be in recess. Jefferson County Court at Law number 2 is back in session. Court is in session with the arraignment docket. When I call your name, please come before the bench. First case is cause number 24CCCR 0032. Case is styled the state of Texas versus Jamarion Stoker. Before the bench right here. Your full name is Jamarion Stoker?
Jamarian Stoker.
Jamarion Stoker. Ms. Stoker, would you please raise your right hand? Ms. Stoker, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth so help you God?
Sir.
Ms. Stoker, you may put your hand down. How are you doing, Ms. Stoker? I'm doing fine, thanks for asking. Ms. Stoker, I have before me a document that is titled Judge's Explanation of Rights to Defend Us Without Attorney. Do you recognize this document? You share this document to her?
I can see it.
Okay, is this your signature on the line that's titled defendant?
Yes, sir.
And are these your initials on the line that state you'd like to have your case reset to hire your own attorney?
Yes, sir.
Now, Ms. Stoker, before you sign and initial this document, did you read the document?
Yes, sir.
Did you understand what you read?
Sir?
Did you understand what you read?
Yes, sir.
Is everything in this document true and correct to the best of your knowledge?
Yes.
Okay, Ms. Stoker, your case is going to be reset to give you an opportunity to hire your attorney. Our court coordinator will reset your case. Once your case is reset, you'll be free to go. Please have a seat in that first chair on the wall. Next case is cause number 24CCCR 1642. Case is style of state of Texas versus Javon Rashawn Jubert. Ms. Jubert, your full name is Javon Rashawn Jubert? Rashawn Jubert? Okay, Ms. Jubert, would you please raise your right hand? Do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? You may put your hand down. How are you doing, Ms. Jubert?
I'm doing good.
That's good, now, Ms. Jubert. I have before me a document that is titled Judge's Explanation of Rights to Defend Us Without Attorney. Do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendants?
Yes, sir.
What are these your initials
JJ.
on the line that states you have hired Langston Adams? Ma'am, that door is locked. You gotta go through the other door. You hired Langston Adams, is that correct? Now, is everything on this document true and correct to the best of your knowledge?
Yes.
Now, Ms. Gilbert, your case is going to be reset to give your opportunity, to give your attorney an opportunity to send a letter of representation to this court. Our court coordinator is going to reset your case. Once your case is reset, you're free to go, and you have a blessed day.
Thank you.
You are. Jarvis Lane. Mr. Lane, your full name is Jarvis J. Lane. Mr. Lane, would you please raise your right hand? Lane, do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. Lane, you may put your hand down. How are you doing, Mr. Lane? That's good, Mr. Lane. I have before me two documents. First document is titled Judge's Explanation of Rights to Defend Us Without Attorney. You recognize this document? And is this your signature on the line that's titled Defendant? And are these your initials on the line that state you'd like to apply for court-appointed attorney? Also, I have another document that is titled Jefferson County Affidavit of Indigence. You recognize this document? On page 2 of the same document, there's a signature above the line that is titled Defendant Signature. Is this your signature? Mr. Lane, before you sign and initial all of these documents that I just showed you, did you read the documents? Did you understand what you read? Is everything in these documents true and correct to the best of your knowledge? Okay, Mr. Lane, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney, and the attorney that will be appointed to represent you in your case is Attorney Giles Cole. Attorney Cole will be given information to contact you, and you will be given information to contact him. Our court coordinator will give you that information. Please have a seat in the first chair on the wall and wait for your name to be called. Next case is cause number 4 CCCR 1406, case of style state of Texas versus Dante K. Williams. Mr. Williams, your full name is Dante K. Williams.
Yes, sir.
Williams, you please raise your right hand. Mr. Williams, do you swear or affirm, tell the truth, the whole truth, and nothing but the truth to help you out? Mr. Williams, you may put your hand down. How are you doing, Mr. Williams? That's good. Now, Mr. Williams, I have before me two documents. The first document is titled Judge's Explanation of Rights, Defendants Without Attorney. Recognize this document?
Sir.
And is this your signature on the line that titled Defendant?
Yes, sir.
Or these initials on the line that state you'd like to apply for court-appointed attorney? I also have another document that's titled Jefferson County Affidavit of Injuries. You recognize this document?
Sir.
On page 2 of the same document, there's a signature above the line that's titled Defendant Signature. Is this your signature?
Sir.
Mr. Williams, before you sign and initial these documents that I just showed you, did you read the documents?
Yes, sir.
Do you understand what you read?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge? Mr. Williams, I've read your answers. Based on your answers, meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you is Attorney Peter Doyle. Attorney Doyle will be given information to contact you, and you will also be given information to contact him. The court coordinator will give you that information. Once you get the information from the court coordinator, you'll be free to go, and you have a blessed day. Please have a seat in that third chair on the wall. Thank you. Boss. Thank you. No, she's snapping everything together. Thanks. Yeah. Adrian Jermaine Carbon. Mr. Carbon, your full name is Cadrian Jermaine Carbon.
Yes.
Mr. Carbon, would you please raise your right hand? Mr. Carbon, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. Carbon, you may put your hand down. How are you doing, Mr. Carbon? I'm doing fine. Thanks for asking, Mr. Carbon. I have before me two documents. The first document is titled Judge's Explanation of Rights of Defense Without Attorney. You recognize this document? And is this your signature on the line that's titled Defendant? Are these your initials that state you like to apply for court-appointed attorney? I also have another document that's titled Jefferson County Affidavit of Injuries. You recognize this document?
Yes.
On page 2 of the same document, there's a signature above the line that is titled Defendant Signature. Is this your signature? Mr. Carbon, before you sign and initial these documents that I just showed you, did you read the documents? Did you understand what you read? And is everything in these documents true and correct to the best of your knowledge? Mr. Carbon, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of court-appointed attorney. Attorney that will be appointed to represent you in this case is Attorney Mark Faggett. Attorney Faggett will be given information to contact you, and you will be given information to contact him. Our court coordinator will give you that information. Once you get the information from the court coordinator, you'll be free to go and you have a blessed day. Please have a seat in that first chair on the wall. Next case is Rashad Jabril Finister. Mr. Finister, this is cause number 23CCCR 2626. Would you please raise your right hand? Swear affirm and tell the truth, the whole truth, and nothing but the truth, so help you God. You may put your hand down. How are you doing, Mr. Finister? I'm doing fine. Thanks for asking, Mr. Finister. I have before me two documents. First document is titled Judge's Explanation of Rights to Defense Without Attorney. You recognize this document? Is this your signature on the line? It's titled Defendant? And are these your initials on the line state you'd like to apply for court-appointed attorney? I also have a document that is titled Jefferson County Affidavit of Indigence. You recognize this document? On page 2 of this document, there's a signature above the line that's titled Defendant. Is this your signature? Mr. Finister, before you sign and initial these documents, did you read the document? You understand what you read? And is everything in these documents true and correct to the best of your knowledge? The Finister, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of court-appointed attorney, and the attorney that will be appointed to represent you in this case is Attorney David Grove. Attorney Grove will be given information to contact you, and you will also be given information to contact them. Our court coordinator will give you that information. Once you get the information from the court coordinator, you'll be free to go, and you have a blessed day. Please have a seat in that third chair on the wall. Next case is cause number 23CCCR 2644. Case is style of state of Texas versus Cammie Nicole Hobson. Ms. Hobson, your full name is Cammie Nicole Hobson.
Yes, sir.
Ms. Hobson, would you please raise your right hand? Ms. Hobson, do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Ms. Hobson, you may put your hand down. How are you doing, Ms. Hobson?
I'm good. How are you?
I'm doing fine. Thanks for asking, Ms. Hobson. I have before me two documents. First document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes, sir.
Is this your signature on the line that's titled Defendant?
Yes, sir.
Are these your initials on the line that state you'd like to apply for court-appointed attorney?
Yes, sir.
I also have another document that is titled Jefferson County Affidavit of Indigence. You recognize this document?
Yes, sir.
On page 2 of the same document, there's a signature above the line that is titled Defendant Signature. Is this your signature?
Yes, sir.
Now, Ms. Hobson, before you sign and initial all these documents that I just showed you, did you read the documents?
Yes, sir.
You understand what you read?
Yes, sir.
And is everything in these documents true and correct
Yes, sir.
to the best of your knowledge? Ms. Hobson, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. An attorney that will be appointed to represent you in this case is Attorney Benjamin Jeffries. Attorney Jeffries will be given information to contact you, and you will be given information to contact him. The court coordinator will give you that information. Once you get the information from the court coordinator, you'll be free to go. You have a blessed day. Please have a seat in that first chair on the wall. You're welcome. Jennifer Sue Hamilton. Ms. Hamilton, your full name is Jennifer Sue Hamilton.
Yes, sir.
Ms. Hamilton, would you please raise your right hand? Ms. Hamilton, do you swear affirm, tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Ms. Hamilton, you may put your hand down. How are you doing, Ms. Hamilton?
I'm good. How are you?
I'm doing fine. Thanks for asking, Ms. Hamilton. I have two documents. First document is titled Jefferson County, first document is titled Jefferson County Affidavit of Indigence. You recognize this document?
Yes, sir.
On page 2 of this same document, there's a signature above the line that is titled Defendant Signature. Is this your signature?
Yes, sir.
And on the next document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant?
Yes, sir.
Are these your initials on the line that state you like to apply for court-appointed attorney?
Yes, sir.
Ms. Hamilton, before you sign and initial these documents that I just showed you, did you read the documents?
Yes, sir.
You understand what you read?
Yes, sir.
And is everything in these documents true and correct
Yes,
to the
sir.
best of your knowledge?
Yes, sir.
Ms. Hamilton, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you in this case is Attorney Jack Lawrence. Attorney Lawrence will be given information to contact you, and you will be given information to contact him. The court coordinator will give you that information. Once you get the information from the court coordinator, you're free to go and you have a blessed day. Please have a seat on the fifth chair on the wall.
Do y'all have a pamphlet for the job training? program?
Yes, hold on a minute. Warren Swan. Mr. Swan, your full name is Warren Swan?
Yes, sir.
Swan, would you please raise your right hand? Mr. Swan, do you swear affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
So help you God? You may put your hand down. I'm gonna need some non-conditions. I already have them, but I need. Miss Mosby.
And her friends are friends, some, oh.
No, I need to. Let's see, I missed them. What? Let's see. Okay, won't you make that copy, huh? Okay, Mr. Swan, your full name is Warren Swan, is that
Yes, sir.
correct? I already swore you in there, is that
Yes.
correct? Okay, now, Mr. Swan, I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorneys. Recognize this document?
Yes, I do.
And is this your
It is.
signature on the line that's titled defendant?
Yes, sir.
And are these your initials on the line that state you like to apply for court-appointed
Yes,
attorney?
sir.
I also have another document. Let's see, it says, hold on a minute. Now, Mr. Swan, is everything in these documents that I just showed you true and correct to the best of your knowledge?
Yes, sir.
Mr. Swan, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of court-appointed attorney. And the attorney that will be appointed to represent you is Ms. Laura Perazzo. Ms. Perazzo is sitting at the table right there. Now, she will be given information to contact you. You also be given information to contact her. If you want to visit with her, that'll be up to her. If today, but
Have a plea to do, Your Honor.
okay. Also, now, you will be given a place to contact her. And I also need to give you some bond conditions. Just hold on a minute.
Okay.
Okay, now, Ms. Swan, you've just been handed a document that's titled Standard Bond Conditions in County Court at Law Number 2. I'm going to go over these bond conditions, which in the states as follows. Following return of a criminal information in County Court at Law Number 2 of Jefferson County, Texas. All bail bonds executed for release of any defendant named herein are ordered subject to the additional conditions. Number 1, defendant shall commit no offense against the laws of this state, any other state, or of the United States. Do you understand that condition?
Yes, sir.
Condition number 2, defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol, and the test indicates the presence of drugs and alcohol in the defendant's body. Do you understand that condition?
I do.
Now, condition number 3 does not apply, and condition number 4 does apply because your case, DWI second, is considered a subsequent offense listed under section 49.01, 49.04 to 49.06 of the Texas Penal Code. And condition number 4 states as follows. A defendant whose information charges any subsequent offense listed under section 49.04 through 49.06 of the Texas Penal Code shall not operate any motor vehicle unless the vehicle is equipped with an interlock mechanism device that makes impractical the operation of the vehicle if ethyl alcohol is detected in the breath of the operator, and said device shall be installed at the defendant's expense with written verification being submitted to the court on or before, actually it's 3 days after the day. Do you understand that condition?
Yes.
And condition number 5 state, that door is locked, ma'am. Condition number 5 states that the defendant shall attend AANA meetings 2 times a week and provide proof to the court. Do you understand that? Okay. And need to give you a signing sheet. Is this my last one?
Make a make copy.
Let me top this all in. Now, the bailiff is going to, before you leave, the bailiff is going to give you the signing sheet that you need to bring to the AANA meetings and a copy of locations in our area that you can attend the AANA meetings. Okay?
All right.
Now, may I see the paperwork that I handed to you, that she handed to you earlier? You can step around here. I just need to make the corrections that says that you have to provide proof to the court of this interlock on or before 3 days after the day. So you have until Friday this week to provide proof. And the way here you go. The way you can provide proof, they could either give you the email address where it can be emailed. They're gonna give you I guess a receipt or the application that's filled out. And you can email it to us, or you can bring it to the court. You would have, if the court is not in session, then you can go through the blue doors that's next to the courtroom.
Yes, sir.
And the lady sitting behind the glass window, you can give it to her, and she will give us that copy to be placed in your file.
Your Honor, I already have the breathalyzer.
Okay, so we just need to have proof of it.
Okay,
So you just need to get that proof to us,
okay.
okay? All right, just have a seat in that chair and wait for your name to be called. He didn't even give me a copy of the paperwork for the NA. Mostly she's copying it right now. Paris Haynes. Ms. Haynes, your full name is Paris Sierra Haynes. Ms. Haynes, you have your purse in your hand? You can put it on the table right there. Thank you. Now, Ms. Haynes, please raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth to help you God? Ms. Haynes, you may put your hand down. How are you doing, Ms. Haynes? I'm doing fine, thanks for asking. Ms. Haynes, I have before me two documents. First document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document? And is this your signature on the line that's titled Defendant?
Yes.
And are these your initials on the line that state you'd like to apply for a court-appointed attorney?
Yes.
I also have before me a document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document?
Yes.
On page 2 of this same document, there's a signature above the line that is titled Defendant Signature. Is this your signature?
Yes.
And Ms. Haynes, before you signed and initialed these documents that I just showed you, did you read the documents? And did you understand what you read? And is everything in these documents true and correct to the best of your knowledge? Okay, Ms. Haynes, based on your answers, meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you in this case is Attorney Todd LeBlanc. Attorney LeBlanc will be given information to contact you, and you will be given information to contact him. Our court coordinator will give you that information. And once you get the information from the court coordinator, you'll be free to go. But before you have your seat, I need to give you some bond conditions. Ms. Haynes, the document that has been handed to you is titled Standard Bond Conditions in County Code Law Number 2. Do you recognize, well, do you see that title on that document?
Yes.
Okay, I'm going to go over this document, which it states as follows. Following the return of a criminal information in County Code Law Number 2 of Jefferson County, Texas, all bail bonds executed for release of any defendant named herein are ordered subject to the additional condition. Number 1, the defendant shall commit no offense against the laws of this state, any other state, or the United States. Do you understand that condition?
Yes.
Condition number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol and the test indicates the presence of drugs and alcohol in the defendant's body. Do you understand that condition?
Yes.
And condition number 3 does not apply. And condition number 4 does not apply. However, condition number 5 does apply. And condition number 5 states the defendant is prohibited from possessing a firearm or ammunition unless the defendant is a peace officer as defined by section 1.07 of the Penal Code, actively engaged in employment as a sworn full-time paid employee of a state agency or political subdivision. Do you understand that condition?
Yes.
Now, Ms. Haynes, if you violate any one of these conditions, your bond can be revoked. And if your bond is revoked, the warrant will be issued for your arrest. You'll be arrested and placed in the Jefferson County Jail. Do you understand? Okay, you can have a seat in that first chair on the wall and wait for your name to be called, and you have a blessed day. Who's the attorney? Was it Tyler? Eric Vargas? Oh. Now, Mr. Vargas, your full name is Eric A. Vargas?
Yes, sir.
Vargas, you please raise your right hand. Mr. Vargas, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. Vargas, you may put your hand down. How are you doing, Mr. Vargas?
Very good, thank you.
That's good. Mr. Vargas, I have before me two documents. The first document, decided judge's explanation of rights to defendants without attorney. Recognize this document?
Yes,
Is this your signature on the line as titled defendant?
yes, sir.
And are these your initials on the line state you'd like to apply for court-appointed attorney?
Yes, sir.
I also have another document that is titled Jefferson County Affidavit of Injuries. You recognize this document?
I do.
On page 2 of this same document, there's a signature above the line that's titled defendant signature. Is this your signature? Now, Mr. Vargas, before you sign and initial these documents, did you read the documents?
Yes, sir.
You understand what you read? And is everything in these documents true and correct to the best of your knowledge?
Yes.
Mr. Vargas, I read your answers. Based on your answers, meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you in this case is Attorney John Macy. Attorney Macy will be given information to contact you. You will also be given information to contact him. Our court coordinator will give you that information. Once you get information from the court coordinator, you'll be free to go, and you have a blessed day. Thank you. Charles Brody Sanford. Mr. Sanford, your full name is Charles Brody Sanford.
Yes, sir.
Sanford, you please raise your right hand. Mr. Sanford, do you swear or affirm, tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Mr. Sanford, you may put your hand down. How are you doing, Mr. Sanford? I'm doing fine. Thanks for asking. Mr. Sanford, I have before me two documents. First document is titled Judge's Explanation of Rights of Defense without Attorney. Recognize this document.
Yes, sir.
And is this your signature on the line that's titled Defendant?
Yes.
And are these your initials on the line that state you like to apply for court-appointed attorney? I also have another document that is titled Jefferson County Affidavit of Injuries. Recognize this document.
Yes, sir.
On page 2 of the same document, there's a signature above the line that's titled Defendant Signature. Is this your signature?
Yes, sir.
Now, Mr. Sanford, before you sign and initial these documents, did you read the documents? Did you understand what you read? And is everything in these documents true and correct to the best of your knowledge? Mr. Sanford, I've read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney, and the attorney that will be appointed to represent you in this case is Attorney Jennifer DeLodge. Attorney DeLodge will give information to contact you. You will be given information to contact her. Once you get the information from our court coordinator, you'll be free to go, and you have a blessed day. Please have a seat in that first chair on the wall.
We should be contacting you at the number you gave me, and we have questions before the information. Thank you. Thank you.
Next case, or the next two cases is Raymond E. Grant. Mr. Grant, your full name is Raymond E. Grant. Okay, Mr. Grant, would you please raise your right hand? Mr. Grant, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. Grant, you may put your hand down. How are you doing, Mr. Grant? I'm doing fine, thanks for asking, Mr. Grant. I have before me two documents. First document is titled Judge's Explanation of Rights to Defense Without Attorney. You recognize this document? The next document, this document is titled Jefferson County Affidavit of Injuries. You recognize this document? And is this your signature on page 2 of this document?
Yes, sir.
And on the first document, is this your signature on the line that's titled defendant and your initials and state you like to apply for court-appointed attorney?
Yes, sir.
Now, Mr. Grant, before you signed and initialed these documents, did you read the documents?
Yes, sir.
Do you understand what you read? And is everything in these documents true and correct to the best of your knowledge? Mr. Grant, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you in your cases is Attorney Ryan Matuska. Attorney Matuska will be given permission to contact you. You will also be given permission to contact him. Once you get that information from our court coordinator, you'll be free to go and you have a blessed day. Please have a seat in that third chair on the wall. Alan Adams. Mr. Adams, your full name is Alan Joseph Adams.
Yes,
Mr. Adams, would you please raise your right hand? Mr. Adams, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
yes, I do.
Mr. Adams, you may put your hand down. How are you doing, Mr. Adams?
Good.
That's good. Now, Mr. Adams, I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yes,
Is this your signature on the line that's titled Defendant?
yes, it is.
And are these your initials online that state you'd like to apply for court-appointed attorney?
Yes,
And I also have a document that is titled Jefferson County Affidavit of Injuries. Do you recognize this document?
yes,
On page 2 of the same document, there's a set of initials on a line that's next to a box that's checked defendant's signature. Is this your signature?
yes,
Mr. Adams, before you sign and initial these documents, did you read the documents?
yes,
You understand what you read?
yes,
And is everything in these documents true and correct to the best of your knowledge?
yes,
Now, Mr. Adams, I read your answers. Based on your answers, you do not meet the eligibility requirements for the appointment of a court-appointed attorney.
When I was in jail, they appointed me a lawyer, and that lawyer I had since contacted, and she had been reassigned to another job position. She's no longer a court-appointed lawyer. Her name was Kevin something or other.
Oh, that must have been a felony case.
Catalina said,
Huh?
it was Catalina.
Who is that?
She was.
Oh, okay, it just be Kevin C. Kelly.
Yeah.
Okay, so,
So she, I contacted her twice, and this last time
yeah, she's not on our court-appointed list here.
yeah, so she's no longer a court-appointed.
She's not, she's on the felony list, not the misdemeanor list.
Yes, exactly. So then she said that I would have to contact, well, I'm here now, so,
Yeah, but she's not on our list.
no, she's not now.
No,
I don't know, yeah, because when I went into jail, they would start out with a felony and then it ended up being a misdemeanor,
okay,
I guess, and that's.
you're right.
They got changed.
Okay, but I read your answers, unless some of these answers are incorrect. It seems to me that you will have enough money to hire an attorney. Okay, so now at this point, you can do one of two things. You don't qualify for court-appointed attorney, you could either request that your case be set to reset to give you an opportunity to hire an attorney. Or if you waive your right to have an attorney, as stated in the document, you would have to fill out a waiver of counsel for purposes of entering guilty plea or proceeding the trial. Okay, so, or you can just represent yourself.
I'm not understanding what the charges have been. I don't know, I know it's, I told felony and then a misdemeanor, but I don't know what class misdemeanor. it
It's a
was.
class A misdemeanor assault with family violence.
Okay,
That's what it says.
so obviously I'll need a lawyer for that then.
Okay, okay. Miss Osby, could you hand this document back to him? He's gonna, I guess, put a line through there and then, he'll, initial that, the line that says you have to hire an attorney.
To put a line through that one.
And then just do this one here.
Yes, sir.
Okay, thank you. Now, Mr. Adams, you just placed your initials on the line and state you'd like to have your
Yes.
case reset to hire an attorney, is that correct? Now, your case is going to be reset to give you opportunity to hire an attorney. Our court coordinator will reset your case, but before she resets your case, I need to give you some bond conditions. I'm gonna go over these bond conditions with you. The document that has just been handed to you is titled Standard Bond Conditions in County Court at Law Number 2. You see that title?
Yes,
And it reads as follows: following the return of a criminal information in County Court at Law Number 2 of Jefferson County, Texas, all bail bonds executed for release of any defendant named herein are ordered subject to the additional conditions. Number one, defendant shall commit no offense against the laws of this state, any other state, or the United States. Do you understand that condition?
yes,
Condition number two, the defendant shall submit to testing for drugs and alcohol. At any time as directed by the court may revoke the bond and order arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol, and the test indicates the presence of drugs and alcohol in the defendant's body. Do you understand that condition?
yes,
And condition number three, the defendant shall now communicate either directly or indirectly with the alleged victim of the pending offense, and the defendant shall not go near any residence, school, or other location frequented by the alleged victim. Do you understand that condition?
yes,
And condition number four does not apply. However, condition number five does apply. Condition number five states the defendant is prohibited from possessing a firearm or ammunition unless the defendant is a peace officer as defined by section 1.07 of the Penal Code, actively engaged in employment as a sworn, full-time paid employee of a state agency or political subdivision. Do you understand that condition?
yes,
Now, if you violate any one of these conditions, your bond can be revoked. And if your bond is revoked, the warrant will be issued for your arrest. You'll be arrested and placed in the Jefferson County Jail. Now, Mr. Adams, you're gonna have a seat in that first chair on the wall. Wait for your name to be called. Once your name is called, you're free to go. You have a blessed day.
thank you.
You are. Dwayne Johnson, Mr. Johnson.
Yes, I'm there.
Okay, Mr. Johnson, I have two cases before me. They are cause number 24 CCCR 0568 and cause number 24 CCCR 0571. Both cases are styled state of Texas versus Dwayne Randy Johnson. Mr. Johnson, is that your full name? Mr. Johnson, would you please raise your right hand? Mr. Johnson, do you swear or affirm, tell the truth, the whole truth, and nothing but the truth to help you God?
Yes, sir.
Mr. Johnson, you may put your hand down. How are you doing, Mr. Johnson?
Good, and somebody done.
I'm doing fine, thanks for asking. Mr. Johnson, I have before me a motion to forfeit the weapon and cause number 24 CCCR 0571. Let me do this here. And before we get to that, Mr. Johnson, I have before me a document that is titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. You recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant?
Yes, sir.
I also have another document that's titled Judge's Explanation of Rights of Defendants Without Attorney. You recognize this document?
Yes, sir.
Is this your signature on the line that's titled Defendant?
Yes, sir.
And are these your initials on the line that state
Yes, sir.
that you like to waive your right to an attorney and represent yourself?
Yes, sir.
Now, going back to the motion to forfeit the weapon, do you recognize this document?
Yes, sir.
And is this your signature
Yes,
on the
sir.
line that's titled Defendant?
Yes.
Now, Mr. Johnson, before you signed and initialed all of the documents that I just showed you, did you read the documents? And did you understand what you read?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
And Mr. Johnson, you like the court to grant this motion to forfeit the weapon to the Beaumont Police Department? Okay, Mr. Johnson, I'm signing the motion to forfeit the weapon over to the Beaumont Police Department. And Mr. Johnson, I also have in each one of these cases, a motion to dismiss. Is that correct, State?
Yes, Your Honor.
And Mr. Johnson, I'm signing the motion to dismiss each one of these cases.
Thank you so much.
You're welcome, and you'll be able to get a copy of this motion to dismiss from the court coordinator in a few minutes. And Mr. Johnson, you can have a seat in that first chair on the wall.
Thank you, enjoy your day.
All right, same to you. You have a blessed day. You could talk to her. Ms. Barazza. Huh? They didn't come through?
When you get that dismissal, I'll just provide it to you.
He just left this here thing. It just went off of this here. Yeah, I sent you both of them. Is Jacoby Judge in custody?
Yes.
Ms. Mosley? Good morning. Sir, you need to take your hat off? Let's see.
Like ran up a bit, you know, it's just that my hair won't do anything. It just won't go any later than like.
Oh, okay.
Like low lights, like the ball.
Mm-hmm.
But I can't do.
I wanted to.
That fits you.
Stand before the bench. Court is in session and calls numbers 24 CCCR 1306 and calls number 24 CCCR 1311. Both cases are styled the state of Texas versus Jacoby Stephon Judge. Mr. Judge, is that your full name?
Yes, sir.
Mr. Judge, would you please raise your right hand? Mr. Judge, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Judge, you may put your hand down. How are you doing, Mr. Judge?
All right.
That's good. Now, Mr. Judge, I have before me, well, Mr. Judge, you are represented in your cases by your attorney, Attorney Laura Perazzo. Attorney Perazzo, how are you doing?
Doing well, Your Honor. Thank you.
And Ms. Perazzo, do you waive a record in Mr. Judge's case?
Do Your Honor.
You are. Now, the state is represented in this case by Attorney Haley Simmons. Attorney Simmons, how are you doing?
I'm good, Judge. How are you?
I'm doing fine. Thanks for asking. Now, Mr. Judge, I have before me in cause number 24 CCCR 1311. I have before me a document that is titled Information. This information is filed by the Jefferson County District Attorney's Office. In this information, it alleges that you, Jacoby Stefan Judge, on or about April 25th of 2024, while you were in Jefferson County, Texas, that you committed the Class A misdemeanor offense of evading arrest detention. Mr. Judge, do you understand what you have been charged with?
Sir.
And to this charge, Mr. Judge, how do you plead? Guilty, not guilty, or no contest?
No contest.
Now, you pleading no contest freely and voluntarily?
Yes, sir.
And are you pleading no contest because you do not wish to fight or contest the charges?
Yes, sir.
Mr. Judge, I also have before me on my tablet a document that is titled Misdemeanor Plea Admonishment, is also labeled as State's Exhibit Number 1. Do you recognize this document?
Yes, sir.
On page 2 of this same document, the set of initials on a line next to a box says check no contingent, which means no contest. Did you place your initials on this document?
Yes, sir.
On page 3 of this same document, there's a signature above the line that is titled defendant. Is this your signature?
Yes, sir.
And on the next document, that's titled trial court certification of defendant's right of appeal. Do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant?
Yes, sir.
At the top of this document, there are 2 boxes checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement?
Yes, sir.
The second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement? I also have before me a document that is titled Discovery Certification. Do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant?
Yes, sir.
Mr. Judge, before you sign and initial all these documents that I just showed you, did your attorney, Ms. Perazzo, go over these documents with you?
Yes, sir.
And did you read and understand everything that she went over?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Mr. Judge, are you a citizen of the United States?
Yes, sir.
State upper states one.
Any objections?
No objection.
No objection. State's Exhibit Number 1 will be admitted. Ms. Perazzo, you advised and counseled Mr. Judge. Is there any evidence that he is currently mentally incompetent to stand trial?
No, Your Honor.
And Mr. Judge, your attorney, Ms. Perazzo, has advised and counseled you. Are you satisfied with her representation?
Yes, sir.
Has she provided full, effective, and competent legal representation? Mr. Judge, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
We do, Your Honor.
And what is the agreement?
In exchange for defendant's plea, the state's offering 80 days in the Jefferson County Jail, credit for 80 days to tax and retire court cost, and we'll be dismissing the companion case.
Okay, Mr. Judge, the state is offering that you serve 80 days in the Jefferson County Jail, but you would not be required to serve any more time in the Jefferson County Jail in this case because you already served 80 days in the Jefferson County Jail. Therefore, you'll be given credit for the time that you've already served. The court costs in this case will be taxed and retired. It simply means that you would not be required to pay the court costs because the time that you have spent in jail has already paid it off. Therefore, the court costs will be taxed and retired. And the state will be dismissing cause number 24 CCCR 1306. Mr. Judge, do you understand the state's offer?
Yes, sir.
Do you think that the state's offer in your case is fair and just?
Yes, sir.
And do you accept the state's offer?
Yes, sir.
Mr. Judge, I'll follow the plea bargain agreement that you have entered into with the state. Mr. Judge, you're gonna stand next to the bailiff and follow her direction. Once you finish following her directions, you'll be free to go and you have a blessed day. You need a copy of the dismissal. Shanice Edwards. Ms. Edwards, your full name is Shanice Marie Lynn Edwards. Ms. Edwards, would you please raise your right hand? Ms. Edwards, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Ms. Edwards, you may put your hand down. How are you doing, Ms. Edwards?
I'm wrong yourself.
No, fine, thanks for asking. And Ms. Edwards, do you have her waiver?
I do not, Judge. This is Andrew speaking.
Ms. Edwards, I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant?
Yes, sir.
And are these your initial on the line that state you would like to waive your right to an attorney and represent yourself? I also have another document that is titled Waiver Counsel for Purposes of Entering Guilty Plea or Proceeding to Trial. You recognize this document? And is this your signature on the line that's titled Defendant? Ms. Edwards, before you sign and initial these documents that I just showed you, did you read the documents?
Yes.
Did you understand what you read?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Ms. Edwards, I also have before me on my computer a document that is titled Information Sheet. This information sheet is filed by the Jefferson County District Attorney's Office. In this information sheet, it alleges that you, Shanice Marie Lynn Edwards, on or about October,
Judge, I believe Shanice Edwards is dismissal.
oh, it is? Oh, let me see. Oh. Now, Ms. Edwards, I have before me a document, a motion to dismiss the case.
Yes, sir.
And I'm signing this dismissal. You'll be able to get a copy of this dismissal in a few minutes. Okay, now, Ms. Edwards, I just signed the dismissal. You can have a seat in that first chair. You're gonna get a copy of the dismissal from our court coordinator. Once you get a copy of the dismissal, you're free to go and you have a blessed day.
Yes, ma'am.
Okay, I moved the other two gentlemen.
Brandon Gardner. And he's rejecting the state's offer, Your Honor.
Okay. Brandon Gardner. Okay, now, Mr. Gardner. Your full name is Brandon Gardner. Mr. Gardner, would you please raise your right hand? Mr. Gardner, do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. Gardner, you may put your hand down. How are you doing, Mr. Gardner? I'm doing fine, thanks for asking. Mr. Gardner, I have before me two documents. First document is titled Judge's Explanation of Rights to Defendants Without Attorney. Recognize this document? And is this your signature on the line that's titled Defendant? And these are your initials on the line that is titled, well, that states you'd like to waive your right to an attorney and represent yourself. I also have another document that is titled A Waiver of Counsel for Purpose of Entering Guilty Plea or Proceeding to Trial. You recognize this document? And is this your signature on the line that's titled Defendant? Now, Mr. Gardner, before you sign and initial these documents, did you read the documents? Understand what you read? Is everything in these documents true and correct to the best of your knowledge? Okay. Now, Mr. Gardner, I understand that you talked to the prosecutor, relayed an offer to you and you rejected that offer. Now, at this time, you can do one of three things. You could continue to represent yourself, or you can request time to hire your own attorney, or if you cannot afford to hire an attorney, you can request that an attorney be appointed to represent you. You understand those? Okay, so what do you want to do?
I will represent myself because it really wasn't obvious like that.
Okay, so now what we're going to do now, obviously the case is not set for the day. So your case is gonna be set for trial at, excuse me, at a later time. But, before that happens, I need to give you what is called a Faretta warning. Now, I need to ask you some questions. Mr. Gardner? Now, have you ever studied law? Have you ever represented yourself in a criminal case? Do you understand the charges against you?
Yes, I do.
You do, okay? Are you aware of the penalty range for that charge? You're not?
Then I had a plan, the A plan.
Hold on a minute. Let me pull up your file. Okay, you've been charged with a Class B misdemeanor interference with public duties. You understand that?
I understand.
Okay. And the range for Class B, the range of punishment, minimum 0 days to maximum 180 days in the county jail, a fine that does not exceed $2,000, or you could be given both such fine and confinement. Do you understand that?
Yes, sir.
Okay. Now, are you familiar with the exact legal elements of of the charge? Do you realize that if you are found guilty, that you can be assessed punishment anywhere within that punishment range? Now, do you realize that if you represent yourself, you are on your own? That is, as a judge, I cannot tell you how you should try your case or even advise you as to how you should try your case. I cannot help you in any way. Do you understand that? Are you familiar with the Texas rules of evidence and Texas case law?
Yes, sir.
You are, okay. Do you realize that the Texas rules of evidence and Texas case law govern what evidence is admitted? And in representing yourself, you must abide by those rules. For example, how to conduct a voir dire examination, and what are the grounds for excusing a juror for cause? And do you understand what is hearsay?
Yes, sir.
And what are some of the exceptions to hearsay? You do. What is proper impeachment for a witness? You understand that? What is proper impeachment for a witness? When is character, do you understand when is character evidence allowed? Do you know when and how to make proper objections? Do you know when and how to move for directed verdict? Do you know how to offer evidence to protect the record for appeal? Do you know the proper grounds for mistrial? Okay. Are you aware that the failure to timely move for a mistrial may waive crucial mistakes made by the state or this court? Do you know how to request and object to jury instructions? Yeah. Are you familiar with the Texas Rules of Criminal Procedure? Do you realize that those rules govern the way in which a criminal action is tried in court? Okay, so have you ever tried a case in court before?
But I haven't been in trial for a charge before.
So you're saying you've been in trial for a charge before as a defendant?
That I caught charges before I went to trial with a lawyer.
That's right. So you was the defendant, but you had a lawyer representing you. Okay. And so you think that because of that experience, that you understand the rules of evidence and you understand the rules of criminal procedure?
I'm not scared to, you know, I understand, you know.
Okay, now,
What I'm facing.
okay, now. Now, I must advise you that in my opinion, you would be far better defended by a trained attorney than you can by yourself. I think it is unwise for you to try to represent yourself. You are not familiar with all the laws that may apply in this case, and you are not familiar with all of the court procedures. Now, you are not familiar with the rules of evidence, and I strongly urge that you not try to represent yourself. Now, in light of the penalty that you might suffer if you are found guilty, and in light of all the difficulties of representing yourself, is it still your desire to represent yourself and to give up your right to be represented by a lawyer?
I'll hire me a lawyer then.
Okay. Let's do this here. So, Ms. Mosby, did you hand this document back to him? He needs to put a line through the waiver, and he says he wants to hire his own attorney, initial on the first line. And Mr. Gardner, in case it's gonna be reset, please stand in front of the court coordinator. She's gonna reset your case.
That I've been out on my bond, I still need to call them.
That's the contract that you have with your bonds. Yeah, yeah, he's resetting the hire. Oh, he was supposed to put a line through the bottom. Okay, there you go. Who's the next gentleman? Mr. Did you give me his paperwork? Did you give me his paperwork? The gentleman back there.
He still has it.
He still had the clipboard.
Yeah. Now that we're their husband.
Oh, that was her husband?
Noise.
We'll be in recess until 1:30 for trial.